I think things went very well. I think we proceeded in moving forward and generating and moving our case that we believe that there was imminent harm at this particular facility based on the most recent actions of a young child being left on a vehicle. I'll state, as I've heard from one of my dear colleagues, we don't have the right to get it wrong. And so it's with that the department looked at a number of different issues and circumstances around this case and made a determination that we needed to move forward on behalf of the remaining children that were there.
If the head of the facility hadn't lied during the investigation, she just said, this is what happened, as to what happened, would you have taken a different action?
I think once again, we looked at the whole totality of the case. There was the issue of the duration of the time that the young child was on the vehicle, the intent to purposely mislead or delay or deceive the investigation, as well as some of the other areas that were found and determined, areas of supervision, areas of record keeping. And so when we move to these serious actions, and I'll share once again, the emergency closure is one of the highest sanctions or penalties that we have to afford Georgia's earliest learners. It is there in purpose so that we can ensure that imminent harm is not there. And so to answer your question, we believe that we still would have moved forward, but we just feel like there was a significant effort to deceive.
So if the judge grants your side, rules in your favor, it would be shut down for 21 days, and then what would happen?
In that 21-day period, we will be moving forward and closing our case. We would be looking at determining what types of other sanctions or outcomes, as well as working with families and parents to ensure that their children would be involved and would have access to other quality care.